The details and implications of the ruling, such as how Meta was fined a record $1.3 billion for violating the EU's GDPR laws, how it was ordered to stop transferring and storing e.u. users' data in the US, and how this could affect other companies and users. Meta, the parent company of Facebook, has been hit with a record-breaking fine of $1.3 billion by the Irish Data Protection Commission, DPC, for violating the EU's General Data Protection Regulation, GDPR, with its data transfers to the U.S. The DPC is the lead regulator for Meta across the EU, and its decision is binding for all 27 member states. The DPC found that Meta failed to provide adequate safeguards for the personal data of its e.u. users, who make up about a third of its global user base. Meta has been using a legal mechanism called Standard Contractual Clauses, SCCs, to transfer data to the US, but the DPC said that these clauses did not address the risks of U.S. government surveillance and interference with data subjects' rights. The DPC's ruling follows a landmark judgment by the Court of Justice of the European Union, CJU, in 2020, which invalidated a previous data transfer agreement between the e.u. and the U.S. known as Privacy Shield. The CJEU ruled that Privacy Shield did not offer sufficient protection for e.u. data from U.S. intelligence agencies, and that companies using SCCs must ensure that data subjects have a level of protection equivalent to that guaranteed by the GDPR and the e.u. Charter of Fundamental Rights. In addition to the fine, which is the largest ever imposed under the GDPR, Meta has been ordered to stop transferring e.u. user data to the U.S. within 5 months, and to stop storing such data in the U.S. within 6 months. This means that Meta will have to remove e.u. user data from its servers in the US, and either store it within the e.u. or in countries that have been deemed adequate by the e.u. Commission. The ruling has significant implications for Meta and other companies that rely on cross-border data flows for their business operations and services. Meta said it was disappointed by the decision and that it would appeal against it and seek a stay on the data transfer order. Meta argued that it had been singled out by the DPC, despite thousands of other companies using the same SCCs, and that the ruling could create a dangerous precedent for the Internet. Meta also warned that the ruling could harm innovation and competition in the digital sector, and create barriers for small and medium-sized businesses that want to reach customers in different markets. Meta said it hoped for a new framework for transatlantic data transfers that would provide stability and legal certainty for businesses and users. The ruling could also affect other companies and users that rely on Meta's platforms, such as Instagram and WhatsApp, which are not directly impacted by the DPC's decision but could face similar challenges in the future. The ruling could also prompt other e.u. regulators to take action against other US-based tech giants, such as Google, Amazon, and Microsoft, which also use SCCs to transfer data to the U.S. The ruling reflects the growing tension between the EU's strict privacy laws and the US's more flexible approach to data protection and national security. The ruling also highlights the need for a global consensus on data governance and human rights in the digital age. Meta has been hit with a record-breaking €1.2 billion, $1.3 billion, fine by the European Union for violating its privacy laws. The fine was imposed by the European Data Protection Board, which oversees the enforcement of the General Data Protection Regulation, GDPR, the EU's flagship data protection law. The fine follows an investigation by the Irish Data Protection Commission, DPC, which is Meta's lead regulator in Europe. The DPC found that Meta had breached Chapter 5 of the GDPR, which sets out the conditions for transferring personal data to third countries or international organizations. According to the DPC, Meta had continued to transfer the personal data of Facebook users from the e.u. and the European Economic Area, EEA, to servers in the US, despite being suspended from doing so. In the DPC said that Meta had failed to provide adequate safeguards for the data, exposing it to potential access by U.S. authorities and advertisers. Meta has strongly denied any wrongdoing and said it would appeal the ruling and seek to suspend the case from proceeding in court.